SJC-11448, Commonwealth versus Valentin.
Good morning.
Good morning, Mr. Palmer. Give us a second, and we'll get you started. Okay, the floor is yours.
Okay, may it please the court, my name is John F. Palmer, and I represent Elvin Valentin, who's the appellant in this case. This is an appeal of a conviction for 2 counts of murder involving an individual by the name of Elvin Valentin, the defendant, and his girlfriend in August of 2009.
So Becht was the girlfriend and Diaz was the boyfriend?
Correct. Well,
We don't know if he was the boyfriend.
got 2 boyfriends. Well, let me go back. The homicide arose out of events that resulted in the shooting of Diaz and the victim, the girlfriend, out of, one might say, we would say, heat of passion, provocation, homicide. The facts, I've raised 4 issues in the appeal. I want to address 2 of the issues in oral argument and reserve the other 2 for the brief. In the event that the court has any questions, of course, I'll entertain questions with respect to all 4 issues. The facts, many of the facts here are drawn from the defendant's own statement that he gave to the police after his arrest. In his statement, he informed the police that for several years prior to the shooting, he and the female victim had been in a relationship, romantic sexual relationship, according to the defendant, and that on the day prior to the shooting, he had learned that the victim was at the hospital. He tried to reach her. He was unable to reach her, and so the next day he called numerous times. She did not return his calls. The next day, he went to see her. She was visiting a friend in the neighborhood, and he drove to see her in his truck. They had exchanged words. She said that she was seeing other people. She didn't want to see him anymore. He said words to the effect, "We'll see about that," and then he went home. Now, this was at about 8 or 9 o'clock at night. 2 hours later, 1 to 2 hours later, she came. She went, in the meantime, she had gone, was taken to the station to pick up a new boyfriend, Diaz, and she came home to her apartment. While she was walking with Diaz along the street, the defendant, who had been sitting at home drinking, grabbed a gun off of a TV where he had the gun, went out and shot both of them. Now, obviously there's some more details that are important in this case, particularly as it relates to the issue of provocation, homicide. I want to address first the issue of the introduction into evidence of a whole arsenal, I call it in the brief, of firearms, weapons that I think was prejudicial, I would submit was prejudicial to the defendant in the trial of this case. After the police had spoken to the defendant on the street, they went back to his apartment with his consent and retrieved the firearm. It was a 9mm semi-automatic pistol that he had used to shoot his girlfriend, former girlfriend, and Diaz. They seized that. In addition, and that was seized from a closet. In addition, they went to a safe that had a combination. He gave them the combination to the safe. They opened up the safe and seized not only additional 9mm bullets, 10 rounds, or I'm sorry, a box that was similar to the bullets that had been used against the victims. But they also seized shotgun shells, rounds of ammunition for an unrelated Winchester rifle, a 12-gauge shotgun, an AR-15 rifle with a scope, a buck knife, a .357 revolver in a holster, a Big SAR semi-automatic handgun, and a black semi-automatic Smith & Wesson handgun.
Mr. Palmer, just let me interrupt you. This isn't exactly what you're going to be driving at, but during the jury selection process, were any questions asked about how people felt generally about firearms, and did the prosecution, for example, move to or use its peremptory challenge to exclude people who were members of the NRA or who were actively involved with firearms?
I think there was a general question to the Venari as a whole, not an individual inquiry, and it didn't specify, my recollection is it didn't specify whether they were members of the NRA or anything of that sort. It was a general question to the Venari about whether they thought they had any feelings about guns that would interfere with their ability to be impartial.
And can you recall whether or not the prosecution used peremptory challenge to exclude people who expressed either a familiarity with or an affinity towards the use of firearms?
No members, potential members of the jury, raised their hand, so
Okay.
it never came up as an issue.
Okay.
So what is the prejudicial inference which you claim arose from the admission of those firearms?
Well, I think the prejudice is that some members of the public might conclude that this was an extremely dangerous person with an arsenal of weapons in his safe, along with all this sort of paraphernalia associated with it.
But the guns themselves were not, other than the murder weapon, the guns themselves were not introduced into evidence.
Pictures of the guns were.
Okay.
Yeah.
But wasn't it also made clear that that it was legal possession of all these guns? That there was nothing wrong with having them?
That's true. That's true. It's legal possession.
It was legal possession, right?
And how did that come in? It came in on cross, I get. But what were the questions asked? Did they ask about whether was there anything to show that to get a license to carry, you need the police chief to approve it?
Well, I think the Commonwealth points out in their brief, it was elicited that they were legal. When the defendant tried to cross-examine and elicit more information about what it takes to become a legal owner of a gun, that was excluded by the judge.
So all that came in is that they were legally possessed.
Right. But I think, I mean, my point to the Chief Justice's question is not that they were illegal. That's not the prejudice. The prejudice is that you've got this arsenal of weapons that makes this person out to be a very dangerous person.
The Commonwealth says that there were good reasons for having the jury understand that he had other guns. It went to extreme atrocity or cruelty. It went to his ability to choose which weapon, his familiarity, so his ability to inflict the kind of damage that he did.
I think, you know, I've thought long and hard about that argument. I just don't see it. I mean, I see trying to fit it into those categories which the court in prior cases has said is a proper grounds for admission. But you had, according to his statement, you had a pistol, the firearm that was used to shoot the two individuals. You had that out in the open, lying on top of either a television. I think he said a television. Then you had in a separate location, in a locked safe, all of this paraphernalia. So.
Yeah, but he had to have picked which weapon to use, right?
But that's true in every. If that were the rationale, every single time you had other weapons, you would admit the entire.
No, but the choice,
arsenal.
being at least as to the premeditation, that this wasn't something that it was just you know, he just happened to have it in his hand or nearby or anything like that, but that because he had other things that he could have used, that he actually made a choice in taking out a weapon.
Yeah, I just see that as a very given the facts of this case, a very tenuous basis for admitting the evidence. I mean,
What about the evidence of his having been awarded an NRA safety certificate was introduced in evidence?
correct.
Doesn't that suggest, along the lines of what Justice Lank was asking you about, suggest that here's somebody who is very familiar with weapons, with firearms, and with their dangerous qualities, and yet has gone to great lengths to ensure that he will use them appropriately. Isn't that relevant evidence of premeditation? That he made a conscious choice to select to select one of these weapons, or to even use one of these weapons that he knew was dangerous and had to be handled and was trained to handle in a particular way in order to handle it safely.
I hear the point. I just can't, to my way of thinking, why not a 357 Magnum? Why not the Big Sour? There's no evidence. There's no connection between why he would use a 9mm as opposed to a 357. There's no evidence of that. So it's just.
If I can turn you to your argument with regard to reasonable provocation, if we accept your argument, isn't any spurned lover going to be able to claim reasonable provocation? I mean, it opens the door to all past boyfriends and girlfriends who are unhappy that somebody has broken up with them and is now seeing somebody else to go kill them and then claim reasonable provocation. Wouldn't that be substantially broadening the scope of what we've allowed in the past?
Well, I think that it's very fact-specific, and the facts of this case I submit in the brief are very close to the Andrade case, which this court decided, and essentially suggested in the Andrade case that a provocation manslaughter instruction was appropriate. Now, Andrade actually was less persuasive, at least to me, for a manslaughter instruction than this case is, because you have here, number one, you have the statement to the person, to the defendant, while the victim was at her friend's house. You have the statement that it's over or it could be over. And then 2 hours later, there's no significant, there was a 7-hour gap in Andrade. There was a 2-hour gap from the time he left the last conversation he had with the victim and he went home. And there were no intervening circumstances in this case, that he went home 2 hours later. He's just sitting there drinking. He sees them. There's further confirmation, and
Well, he sees them. He sees her walking with a man. Was there any indication that they were embracing anything, that there was anything sexual about when he encountered them?
no, but again, the facts as related by the defendant, we're not talking about whether you and I as jurors would be persuaded by the evidence. The question is whether he's entitled to an instruction. His statement was that he associated the two of them being together with having a sexual
Well, I understand that, but I mean, I guess the issue is that enough? Is the mere fact that he is spurned by a woman who he did not want to leave him, and that she has decided in his mind to begin to take on somebody else, that is enough to lower the rate of murder to voluntary manslaughter with a 20-year max?
In Andrade, the court found, or suggested that it was sufficient that he had seen, that the defendant had seen his wife in a car with another man, period. That was it. 7 hours later, in the bedroom, he stabs her to death.
But that was his wife.
That was his wife.
And Andrade involved a suspicion that had come to full fruition upon seeing the two together. But here, it seems to me what's different is that it wasn't a suspicion. She actually told him that she was seeing another man and that they were through.
She told, that's right, but she had, but my point is that she told him that 2 hours before he went home, and there were no intervening circumstances, and then there was the further confirmation when he saw the two together. One, the jury could have inferred that in fact he wasn't sure, that he, as in Andrade, it was a suspicion that needed confirmation. Moreover, in Andrade, it was 7 hours from the time that he had been told or he had seen the confirmation of the time that he stabbed his wife. To Judge Lank's point, I don't believe this court has definitively stated whether it makes a difference if it's a relationship, romantic sexual relationship, not involving marriage as opposed to a marriage.
No, but, you know, it's not like these people were living together.
Well, according to the defendants,
They had separate apartments.
they did have separate apartments.
They were
but
not domestic partners. They were not, you know, I mean, it's you don't think it makes any difference at all, the nature of the relationship, to whether or not somebody could be reasonably provoked?
I think
Somebody like on one date with somebody, that doesn't make a difference as opposed to,
according to the defendant's
long-term
statement, they
relationship.
had a 4-year romantic sexual relationship where he would come over, she would come over to his house 4 days a week on it.
okay.
So
Was it clear, it wasn't clear from the briefs, whether that ended at some point and it was less
it's a little,
of a relationship?
well,
the
I think
point.
certainly from her point of view.
Right.
But not from the defendant's point of view.
He was harboring hope.
If I can turn you to your argument with regard to the words to find intoxication, you were challenging. Now, the judge used that essentially with the jury to say, you know, there's evidence that there was intoxication, but I'm not telling you there was. So the judge would preface it by saying, if you were to find that there was intoxication, then you may consider that. And you're saying that shifts the burden. But what's a judge supposed to do? How is a judge supposed to make reference, say, to intoxication without suggesting to the jury that the judge is telling them that there was intoxication and is making clear to them that this is something that is up to them to determine?
Well, I think the model instructions deal with that. And that is to say that where there's evidence of intoxication, you may consider that as a factor in determining whether or not the Commonwealth has proved the intention or knowledge that are required for murder beyond a reasonable doubt. And that's the way you're supposed to do it under the model instructions. Now,
Implicit in that is if you were to find credible the evidence of intoxication, or if you were, I mean, the jury, implicit in that is the view that the jury is making some view that evidence is credible, otherwise it doesn't come into the calculus.
if there is credible evidence, I suppose. But I think that if you look at this court's decisions over the years on the use of finding language in this context and other contexts, it's disfavored. It's just that this court hasn't reversed a case based solely on finding language with intoxication or, for that matter, mental impairment. My point is that in this case, although the judge instructed the jury correctly in the main body of his instructions, when he came back, the last thing the jury had was this repeated finding language about intoxication that is burden shifting. And you'll also notice that he doesn't clearly reiterate the burdens of proof as he had in the main body of his instructions. He didn't reiterate those burden of proof instructions in his supplemental instructions. So the last thing the jury has is a statement that essentially says that the defendant has the burden to prove intoxication.
Okay, thank you.
Thank you.
Good morning, Your Honors. Rachel Van Duren for the Commonwealth, asking this court to affirm the defendant's convictions for the first-degree murders of Nettie Becht and Louis Diaz.
Can I ask, why were these guns relevant?
These guns were relevant for two purposes. One goes to deliberate premeditation, the other goes...
How does it go to deliberate premeditation? Yes, he had a gun with him when he was watching television, apparently and drinking, and he used that gun to shoot the two victims here. So.
But it shows that because there were other weapons available to him in the apartment, his selection of the 9mm gun that he used was one of several conscious choices that he used in the moments leading up to the murder.
So I have two guns. I grab one of them and shoot someone. The fact that I have two guns is evidence of conscious deliberation? I don't understand.
Perhaps on its own that would not be enough to show deliberate premeditation, but in Commonwealth v. Tasserini, this court specifically said that choice of guns is highly relevant when deliberate premeditation is an issue in the case, which it absolutely
I don't really
was.
understand that. It's highly relevant? The choice of guns is highly relevant? One pistol versus another?
It was one of several conscious choices that he makes. He made the choice to select that gun over others.
And the difference would have been if he'd chosen another handgun?
Well, I certainly can't put myself into the defendant's mind, but just speculating, he chose to use a semi-automatic weapon that requires just one trigger pull per bullet rather than using a gun that wouldn't be semi-automatic. It would have taken longer to actually rack the gun. That could have been a part of the choice. I can only speculate as to that and say that...
This played out at trial as to why this was, that he had these choices. He had semi-automatics, he had others. And I mean, was this actually an issue at trial?
Well, no,
some of the guns would require loading, and therefore it was conscious for him to take a gun that just required him to pull the trigger?
There wasn't specifically an argument made to the jury that the guns were there as evidence of his deliberate premeditation. However, the nature of the various guns that the jury did see pictures of and hear testimony about was described, and the jury did hear testimony at length about the nature of a semi-automatic weapon, that it requires one trigger pull per bullet compared to other types of guns that do require additional steps.
Did all of his other guns require these additional steps?
No, I believe it's two of the other guns were similar to the gun that he selected. But it doesn't even necessarily need to be that his choice of this gun over other ones was well thought out or necessarily preferable. It was just one of many conscious decisions that he made as he was deliberately premeditating these murders. The evidence was also relevant to the point of extreme atrocity and cruelty. From the evidence of the defendant's possession of firearms, from his NRA certificate for firearm safety, the jury could have reasonably inferred that this was a defendant who did have some amount of experience with firearms, that he had possibly actually fired a weapon before, perhaps more than once.
An owner of weapons, which our Supreme Court says, should be entitled to have them if they are holding them legally. Mm-hmm. And in this case, he has the licenses. You can use that against them, even when none of those weapons were used in connection with a crime.
Well,
that part is a leap. So any person in this country who has an arsenal, all of which is legally in possession of that person and legally in a receptacle that no child can get to, all of this was done.
Yes.
You can still use that, as you did in this case. It's
not in all cases.
Why this one?
This one, because the defendant...
Just the choice thing?
No, it goes to extreme atrocity and cruelty in addition to the choice thing. The defendant displayed incredible shooting skill. He fires 10 bullets and manages to inflict 15 entrance wounds. Every single one of his bullets hits his victims, and that goes to one of the factors that the jury can consider.
Was he standing far away from them?
There's no testimony as to the exact distance. What we do know is that the defendant's 2 victims were shot when they were approaching the steps to their building, and that he had been coming out of that building. So presumably
Right.
he wasn't
He was
very far
close,
away.
actually.
But in order to inflict 15 entrance wounds with only 10 bullets, one of the factors in Commonwealth Cunin that this court has said juries can consider is the defendant's indifference to or pleasure in the victim's suffering.
Okay, now why does that connect up to his skill?
Because this was not, the jury could have inferred that the defendant causing such excessive suffering, such excessive wounds in killing his victims, that it was not an accident, that it was the intended result of a skilled shooter, that this defendant, given his collection of firearms, given his certificate and the other related materials, was actually an experienced shooter, and that he intended to inflict a disproportionate amount of suffering.
But you offered into evidence the NRA certificate.
Which shows a certificate in firearm safety. It's hard to imagine that the jury would have inferred
But why do you need
bad
anything
character
beyond
from
that?
that.
Why would you need anything beyond that?
Right, I mean, once you have that in, what's added by the number of firearms?
Well, the question isn't whether the Commonwealth actually needed all of these firearms in order to prove the case. It's whether it was relevance and whether that relevance was outweighed by undue prejudice. And it's the Commonwealth's position that there wasn't undue prejudice in this case because there was uncontested testimony that the defendant lawfully possessed all the firearms, that he maintained them safely. And if I could just touch on, the court had asked a question about whether the jury had been, in the jury veneer, my apologies, whether they had been asked about prejudice involving guns or gun violence. The jury was asked, and one of the jurors actually did say that he had had an experience with gun violence. It's juror 92. The question is asked in transcript 1 on pages 26 to 27. That juror is removed from the jury on pages 137 to 138. So there's really nothing in this record that would indicate that any of these jurors would have inferred that the defendant had a bad character or a violent nature simply because he lawfully possessed firearms. And not only was the jury informed that the defendant lawfully possessed these firearms, when one of the officers was asked, hey, what happened to these firearms after you were done inspecting them? The officer says, we returned them to the defendant's family. From that testimony, combined with everything else, it's hard to imagine the jury assuming that the evidence of these other firearms had anything to do with bad character or propensity for violence. And I would also just note that it did seem to be a part of defense counsel, trial counsel's strategy to actually have these weapons admitted. At the beginning of the introduction of the firearms evidence, not only does he not object, but he says, Your Honor, I'm not going to object to any of this. And then with the introduction of every single firearm, he doesn't just remain silent. Trial counsel says, Your Honor, I don't object. And his purpose for that becomes clear when we get to his attempted cross-examination regarding these firearms. Defense counsel makes it clear that his purpose, his trial strategy, albeit an unsuccessful one, is that he wants the jury to know that in order to obtain a firearms license, that you have to meet certain criteria. Trial counsel for the defendant seemingly wanted this evidence admitted, not because it would show the defendant's bad character, but he seemed to believe that it would show the jury the defendant's good character. The trial judge precluded this questioning, but trial counsel had attempted to elicit testimony that in order to obtain a firearm, that you could not have had a violent criminal history.
Interesting.
So why was it
Sorry.
why was it excluded? Why was defense counsel's question precluded?
I believe the trial judge's reasoning in saying that defense counsel couldn't go that far was that it wasn't necessarily relevant. I don't believe that the trial judge really explained his reasoning on that point at length, but he did permit defense counsel to elicit testimony that all of the firearms were lawfully possessed and that in order to obtain the licensing that the defendant did meet certain criteria. He just wasn't allowed to elicit testimony as to what exactly that criteria would involve.
Turning to the voluntary manslaughter,
Yep.
lack of provocation. So essentially the jury was given the option of first degree, second degree, or not guilty, that's it?
They were also instructed on second-degree manslaughter, just not in the context of reasonable provocation.
Second degree manslaughter.
So there were 4 options on the jury verdict slip. It
Sorry,
was
what's second-degree manslaughter?
Sorry, not second-degree manslaughter. They were given the option to find first-degree murder, extreme atrocity and cruelty, first-degree murder, deliberate premeditation, manslaughter, or not guilty. But they were
Manslaughter?
what?
Manslaughter?
Yes.
On what theory?
The jury was not instructed on a specific theory. They were just instructed if you don't find deliberate premeditation or extreme atrocity and cruelty, but rather find the lesser definition of malice, that they could come back with manslaughter.
Was the jury given the elements of manslaughter?
Yes, there was a full instruction. I'm wondering if
Involuntary manslaughter?
what?
Of involuntary or voluntary?
It's not made clear in the transcript. I'm trying to see if
Well,
I
the
actually
elements
have
should be clear from the
site.
elements the judge gave.
What?
Should be clear from the elements the judge gave, whether it's a voluntary or involuntary.
I believe it's voluntary. The judge explains that the jury, if the jury finds malice in terms of reckless behavior that resulted in the crime. I'm sorry. I'm trying
The
to find
third
this.
prong malice.
What?
Third prong malice.
Yes.
But third-pronged malice is not manslaughter.
Right.
Okay, I apologize if I've misspoken. I know that there were 4 options on the verdict slip, and that it was 2 first degree, 1 second degree, and also a not guilty.
So what was the evidence with respect to the sort of sequence of events as this romantic relationship unwound?
In most favorable to the defendant?
Yeah.
According to the defendant's own statements, he and the victim did have some sort of a romantic relationship that did span a certain amount of time, potentially years. He also makes statements that sometime before the day of the murders that he was informed that this victim was seeing somebody else.
By
that,
her?
What?
Was informed by her?
Yes, by her, that she was seeing somebody else. He says something to the effect of, I don't want her to go with him. This guy doesn't seem like he would have a job. This man can't actually provide for her. And he tells her, because he says that she had cheated on him years in the past, he didn't like it. And he tells her, you know, if you're going to do this again, don't do it in my face. So it's not even so much a plea, you know, please don't cheat on me again. He's more just saying, don't do it in my face, because I don't know what my reaction's going to be. Okay. He also testifies, rather, he does not testify. He makes statements to the police, I apologize, that in the weeks leading up to the murder, that she doesn't want to go to his apartment anymore. He makes statements that the day before the murder, he called her, I believe he says thousands of times or 1,000 times. She doesn't take his calls. So on the night of the murder, the timing isn't entirely clear. It seems like it's around 8 p.m. He goes and he actually finds her at her friend Trisha's house, and he says to her, you know, why don't you come back to the West Lawn housing development with me? Come with me. Don't go out with this guy tonight. You should come back with me. Just don't rub it in my face. And she refuses. She says something to the effect of, according to him, we're over. I'm not going with you. Goodbye. And then, according to his own statements, and also her friends who overheard parts of the conversation, he says something to the effect of, we'll see, or we'll see about that. He then goes, I believe his statement is, he goes straight back to his apartment. He goes upstairs. He says he pours himself a drink. He keeps the lights off. That way, if Nettie comes back and she looks up, it will seem like he's sleeping, and he watches by the window.
He says that part?
Yes. So in the record appendix, where
Sleeping, I mean, yeah.
Yeah, it's not as clear, but reading that in conjunction with the Officer LaLiberty's testimony, recounting that evidence, it becomes very clear that his statement is that he kept the lights off so that it would appear that he was sleeping. And then he says that he waits by the window so that he can catch her cheating on him. And that's pretty much his account of the events directly leading up to the murder.
And so some of the friends at this event earlier that evening also witnessed portions of this discussion?
Yes, her friends Tricia and Marie were both outside while the defendant and Nettie were speaking in the driveway. They testified that the conversation appeared calm, that there were no raised voices, that the defendant approached Nettie calmly, that when he walked away and then drove away, it also seemed calm. One of the words that seems to be used throughout the transcripts to describe the defendant's demeanor during these interactions is that he seems very casual, very calm, really not overly excited in any way.
But did they hear any of the substance of the conversation?
They don't really testify to much of the substance. I think one of them says that she hears the defendant say something, we'll see, but beyond that, it's really the defendant's own statements that go to the content of that conversation. So sticking with this, whether the defendant was entitled to the manslaughter instruction, I would just like to emphasize that the status of this relationship just simply doesn't rise to the level of the relationships that we see where defendants are entitled to this instruction. Perhaps the defendant in his own mind believed that they were still in some sort of a romantic relationship, but that in itself simply cannot be enough.
And when would the relationship have ended?
In the defendant's mind, or according?
Well, I don't know. You said status. I mean, how are we to judge that?
So the defendant says that at the time of the murder, he still felt that Nettie was his girlfriend, but he also testifies that in the weeks leading up to the murders, that she no longer wants to go to his apartment, she no longer goes with him, and that...
But it's just weeks. I mean, they've been together for 4 years.
But even his account of their relationship of being together for 4 years still describes a relationship that doesn't even come close to resembling the engagements or marriages that we see in these cases. He describes a relationship that involves them going to each other's apartments occasionally, him supporting her financially. Her friend says that when the defendant would lend Nettie money, in exchange she would clean his apartment to pay off of her debts. So they certainly did have some sort of a relationship, but whether it was a romantic relationship where society is willing to recognize his frailty in the face of what he perceived to be infidelity seems questionable.
So is your view that if they had been married, it would have been different?
The defendant still would not have been entitled to the instruction in this case. If we look at the defendant's actions in the moments immediately after he commits these murders, even looking at the strongest cases cited in my brother's brief, be it Andrade and Schnapps and Simmons, it's just drastically different. In this case, because the standard for the heat of passion manslaughter instruction is the defendant's capacity for reflection and restraint eclipsed. In this case, the defendant is a picture of reflection and restraint. His actions immediately after the murders are to go into his apartment, according to his own statements, put away his guns, and then call his children to arrange for a defense attorney in case he needs one.
Except that Mr. Palmer's point is that it's one thing to hear about something. It's quite another thing altogether to see it right before your eyes, to see it unfolding. And he's saying that it's the visual encounter that provoked him.
The visual encounter, by all accounts of what happens, is simply Nettie walking next to a man. There is nothing more there. The least provoking example that I can think of in any of the cases is in Andrade, and in that case, the husband sees his wife in a car when she's supposed to be someplace else. And the court said even in that case, while the defendant in that case was entitled to the instruction, the court describes that case for the instruction as flimsy at best, that it was a possible but unlikely result. And again, comparing the defendant's actions immediately after the murders to other cases, in Schnapps we have the defendant in a hysterical state. He shoots his wife and then he shoots himself. In Simmons we have the defendant in a hysterical state, stabs his wife, then starts stabbing himself. When police officers arrive, he's described as catatonic, and then later when he's in the hospital, he's described as hysterical and he's pulling out his own IVs and screaming that he wants to die. In Andrade, we have the defendant stabs his wife to death 42 times, and then presumably in a complete absence of reflection, goes back to bed covered in his wife's blood so that, in his own words, he can attempt to relax.
So in this case, if he had shot himself and survived, he would have been entitled to a manslaughter instruction?
If they had a stronger relationship, if he had shot himself in a hysterical state and survived, and if what he had actually observed was more provoking, if he had actually learned of this infidelity in his mind more than days in advance, then perhaps he would have been entitled to the instruction, but this case just simply doesn't rise to the level of what we see where the instruction is given.
All right, thank you.
Thank you.